Welcome to our newest video segment, the 9 things that you should know about a plea agreement. My name is Zachary Divelbiss. I'm the owner of Future First Criminal Law. I'm a licensed attorney here in the Phoenix, Arizona area. And if you're facing criminal charges, then this is a must watch. A plea bargain is going to be offered in your case, so you need to know the basics of what this is before you even get to court. Here we go into it, the 9 things that every defendant should know about plea bargains. Once again, this is the basic. Here's our quick overview. Most criminal cases end with a plea bargain rather than a trial. Once again, most cases end with a plea bargain rather than a trial. In fact, at the felony level, the statistics are about 98% of cases are resolved without going to trial. So whether a case is dismissed, ended through a diversion program, or a plea agreement, only 2% of cases actually go to trial at the Maricopa County felony level, the highest level we get here at our state court. So if you're facing criminal charges or if a loved one is charged with a crime, it is important to understand the fundamentals of the plea bargaining process. So that way you can discuss your options intelligently with your criminal defense lawyer. One of the things that I want to say here before we get into even the first steps is the fact that we use these legal terms called plea bargaining. They are interchangeable with some of these other words. A plea offer, a plea agreement. All of these words are the same, so don't be confused when I use them interchangeably here in this video, or if you're a lawyer, you hire us, if we call everything a plea offer, a plea deal, a plea bargain, it's all the same. Here is our first one that you must know. A plea bargain is a negotiated settlement. Plea bargaining is the process of negotiating to resolve criminal charges without a trial. The plea bargain is essentially an out-of-court settlement for a criminal case. If you've been involved in any kind of civil cases, so any kind of personal injury, you've been in a car accident, and your lawyer there says, hey, here's what the insurance company is willing to do to settle this. This is the same thing. This is the same equivalent. The prosecutor presents a plea offer in order for us to end the case before a trial. Please understand that your criminal case, no matter what, will end up at a trial if you let the case go on long enough. So this is the first step. This is the first thing you should know about plea bargains. The second thing that we're going to get into is something that is not classically referred to this way, but this is the 2 basic principles of plea agreements. So the 2 categories of plea bargains exist. Pleas that involve the changing the bargain, and then there's pleas about the sentence. Very, universally known, and we're going to get into this and why we kind of draw 2 different distinctions here. So a plea bargain is one in which a prosecutor agrees to dismiss or forego certain charges in return for you to plead to other lesser charges. A sentence bargain is one where the prosecutor agrees to recommend a particular sentence or sentence range. The prosecutor's recommendation is simply that, a recommendation. It is not binding on the judge. This is very important, especially at the felony level. But you can withdraw from your guilty plea if the judge deviates from the recommendation at the time of sentencing. So I want to talk about this sentence here just a little bit more. If we put in writing that you agree to a certain outcome in your plea agreement, and it is a 100%, this is how many days of jail, this is how many years of jail, and the judge changes that, then you do have a right to back out of the plea agreement. Understand though, this PDF and many of the things that you may find online are going to slightly vary here, because technically the prosecutor can recommend a sentence at sentencing that is or isn't in the plea agreement, and sometimes the judge is allowed to change that. This is what happens when there's a range. A range is something that the prosecutor sets, let's say 1 year to 5 years of prison, well, now the judge can pick anywhere between there, and that is final. There's nothing we can do to undo it at that point. The final sentence here that we have is, thus the value of the sentence bargain depends largely on the judge's practice in deferring to prosecutors' recommendations. This is essentially saying that prosecutors hold a lot of weight here. Prosecutors are really good at convincing judges to go with the harsher sentence rather than a lower sentence. But that's why you have a criminal defense attorney. That's why you should have us on your side if you're even thinking about using a plea agreement and getting to sentencing, so that way we can try and get you to the lowest sentence possible if it gets to that point with the judge. The third term that we need to know here is a guilty plea constitutes a waiver of constitutional rights. When you agree to plead guilty, you also agree to give up or waive these constitutional rights: the right to a jury trial, the right to confront and cross-examine your accusers, the right to remain silent, and the right to refuse to incriminate yourself. You might be asking yourself, well, this is really strange. Why am I giving up constitutional rights? I thought I always have constitutional rights. And that is true. You will always have your constitutional rights every day when you walk outside of a courthouse, every day when you're driving down the street, walking on the sidewalk, all of those things. You don't lose them forever. However, for this particular case that you're accepting a plea agreement to, one of your main constitutional rights is to have a trial. But you can't do both of those things at the same time. You can't on one hand say, well, I want a trial. I don't believe, I've been fairly accused. And then on the other hand say, well, I want a plea agreement. The judge says, we're not going to play that game, so you have to, by law, get rid of your constitutional rights, the ones I just went over, in order to accept a plea agreement. Very interesting concept here, because not a lot of people really even knew they had rights, and then you get rights going through the criminal justice court process, and then they get taken away when you accept a plea agreement. So very, very important part that you should be discussing with your lawyer is your constitutional rights. This is something that we are required to ethically, even if we weren't ethically required to, we would absolutely be advising you of your constitutional rights and what happens when you accept a plea deal. This is also very important because some people say, well, I would like to have my trial on this part of the charges, say for this first charge, but then I would like to accept a plea deal on this charge. Something like that's not possible. It's an all or nothing. So very important, if you're facing multiple charges, to hire a law firm to help you with this. Getting here to the fourth topic I want to cover here is a guilty plea must be made knowingly and voluntarily. So you will enter a plea at your hearing, that the judge is there. The judge will ask these questions of you to ensure that the plea is entered knowingly and voluntarily. The judge will not say it verbatim like this. The judge will essentially go over this in a comprehensive way. And at the felony level, it's very structured the same almost every single time for every single person. So they will ask you questions about your mental competence. They will ask you questions concerning the satisfaction with your legal representation. There will be questions to ensure that you understand the legal rights that you are surrendering by pleading guilty, including your trial rights and your appellate rights, post-conviction rights. Questions to ascertain your understandings of the penalties for conviction, questions about the plea agreement and other threats or promises made or lack of threats or promises, and questions to assure the judge that there is some factual basis for your guilt. Very important, the judge doesn't just look at a piece of paper and sign off on it. The judge will ask you questions along these lines to make sure that you are knowingly entering a plea agreement to the punishment that you believe and you agree to, and the judge will make sure you did this voluntarily. So nobody has forced, threatened, harassed, coerced you in any way. Some of our future videos are going to get into very specific plea agreements. There I will get into some of the very specific wordings the judges will get into. We as your defense attorneys will be with you during this entire process of sentencing after accepting the plea, at which point if you're ever confused about one of these things, you can always look to us and we'll be there to help you answer them. sometimes these judges can get a little bit tricky about what you agree to waive and not waive, and what you're, voluntarily saying versus not. So one of the things we prep you for, so that way you make sure everything goes smooth. Coming up next here, we have a guilty plea counts as a criminal conviction. This is paramount. A guilty plea entered as part of a plea bargain counts as a conviction, and you will be subject to all the collateral consequences that accompany a criminal conviction. Depending on what you plead guilty to, these are some of the things that might apply. I also want to let you know that the collateral consequences is an umbrella term, meaning there are a ton of different things that can come into play with your conviction, and these are just some of them. Immigration-related consequences. If you're not a legal U.S. resident, meaning you don't have legal permanent status or temporary status, pleading guilty to certain crimes could essentially cause you to be deported or to start an immigration process. Employment-related consequences. If you're a teacher here in the state of Arizona and you plead guilty to a criminal violation, to certain criminal violations, you absolutely can and will lose your teaching qualifications that allow you to be certified to teach in Arizona. In addition, there are many other employment-related issues that may come up, and losing those license and qualifications. The loss of professional licenses. Very common for our nurses, our doctors, lawyers, accountants, all kinds of different people become affected when there are professional licenses and you have to plead guilty to a criminal conviction. Loss of voting privileges, prevalent for all of our felony cases, especially if you're a repeat felon, is where it really hits you. Loss of driving privileges, absolutely one of our most common consequences for any of our driving cases, especially DUIs, but even as low as speeding tickets, criminal speeding tickets, reckless driving, aggressive driving, hit and runs, leaving the scenes of accidents, major driving license-related consequences that will come up there. Loss of the right to possess firearms. This is absolutely felony cases, but you might even be surprised that even with domestic violence type cases, domestic violence can be attached to almost any kind of charge, as far as disorderly conduct, assaults, arguments, all kinds of different things there can be classified as domestic violence. And domestic violence charges and convictions, where there's on probation required, you very well could be losing your right to possess a firearm. Very tricky situation here, even for us lawyers, so please consult a knowledgeable lawyer if this is something that you actually care about, your Fourth Amendment right to carry a firearm, and you have a domestic violence related situation or a felony situation. There are a ton more situations too, so please, if you actually care about it, have a consultation, hire a lawyer, try and get those charges reduced or dismissed or changed in any way. Number 6 that we get into here is that juries are unpredictable. So no one can calculate precisely your chances of acquittal. However, certain factors may tip the scales and help you decide whether to take your chances at trial or to strike a bargain. Some of these factors will include this, not limited to, there are plenty more. But what are the witnesses going to say? Police officers are witnesses. Lay people, other drivers, neighbors. Are they credible? Did they actually see what happened? Do they themselves have a bunch of priors and are unreliable? Will they appeal to the jury? Will they present well to the jury? Police officers are trained to testify to juries. Your neighbor may not be. What physical evidence does the prosecution have? Was it lawfully obtained? And can it be suppressed? What is the prosecutor's reputation? What is the maximum sentence you are facing if you are found guilty at trial? This fourth factor here is typically the most important one, especially at our felony level, because our felony sentencing laws are incredibly extreme, especially if you have prior felonies. This is what largely leads to that 98% of cases that do not go to trial is due to prior felonies and due to Arizona's sentencing laws, and we do have mandatory sentencing requirements. There will be other videos to discuss that further for you to watch. The seventh one is your decision may hinge on personal factors. The decision to plead guilty or proceed to trial is unique for each individual. Weigh your options to consider your age at the time of accepting the plea, your appetite for risk, whether you're willing to roll the dice at trial, your ability to endure a stressful trial, how long it can be, mentally exhausting, physically exhausting, how much time you can lose at work, your prior experience with prison, if any. If you've never been to prison or even jail, it's not a fun place. Will you survive? Yes. Do you want to risk not? Maybe not. And your family situation. Are you going to have to give up your kids, your spouse, significant others, lose your house, not be able to provide child support, child care, education? Ton of family dynamics here that play into the fact that plea bargaining sometimes will solve those problems. The eighth reason we have listed here that you should know about plea bargaining is it's your decision. The decision to plead guilty or to go to trial belongs to you, not your lawyer, not the prosecutor, not the judge. Once again, the decision to accept a plea deal or go to trial is yours and yours alone. The guidance of your attorney should help you make the decision, but you are the only one who can do it. We, as your lawyers, cannot force you to go one way or the other. Our job is to educate you about your options and then advocate for you for the best decision possible once you make it. The law places the final decision in your hands because you are the one who must live with it. Given the gravity of the decision, it is best made with counsel of a trusted and experienced criminal defense lawyer. Please don't try and solve a case on your own. Please don't try and talk to a prosecutor to decide if it's a good plea deal or a bad plea deal. Please don't try and tell the prosecutor why your family's going to be impacted by this and why you thought I just moved to Arizona. I didn't know the rules. This was my first time making a mistake, prosecutor. Please go easy on me. The judge will totally dismiss my case once I tell them who I am. The judge will go easy on me. I've never been in their courtroom before. These are all fallacies. You, at the end of the day, have to make the choice whether to go to trial or accept a plea deal, and you should not be doing anything else without a lawyer if you actually care about your future. Finally, once the decision is made, it is very difficult, in fact almost impossible to undo. After sentencing, you can withdraw your guilty plea only if you can demonstrate that it was made unknowingly or involuntarily. Very, very, very high standard, because the judge essentially makes sure that you knew that you were knowingly getting into the situation, the outcome that you signed on the plea agreement. And it's very difficult to say that anybody after the fact or previous to it forced you to enter into that plea agreement. There is a third one, beyond extreme rare, but this is the gross manifest injustice. If there was somehow something that nobody foresaw coming and you accepted a plea deal and this plea deal caused a very gross injustice that was unforeseen, then that would be a third and final way to back out of a plea agreement. Also understand, not really to go into it in this video, there are a ton of my other videos that go into this. There is typically a time requirement, 90 days for our felony cases here and our misdemeanors and our criminal cases to do this. It's called post-conviction relief. You don't just get to decide to get out of your plea agreement 5-10 years down the road. So very important. Once again, this is the basics of what is happening with plea agreements. These are the basics that you should know if you're facing criminal charges. These basics are not meant to help you handle your case yourself. The basics here, the 9 things that I've gone over, are simply to make you more educated if you're going through this system yourself. It's to help educate you when you have a lawyer. It's to help educate you if you are consulting different lawyers to ask them their position on some of these different things. Of course, usually when you're doing a free consultation, it's a little early to know how these 9 factors will play in. But at least now you have a great understanding that what we do here at Future First is we take care of you. We make sure that we educate you about your case. So that way, when and if you decide to take a plea agreement or go to trial, you are making the best knowledgeable decision that you can. If you have any further questions or if this speaks to you, please don't hesitate to contact us. We are more than happy to have a consultation with you, a family member, or any loved ones that you know.